freedom of speech, freedom of speech, freedom of speech, but that is not correct. Okay, so while Congress cannot ban free speech, the Supreme Court has sanctioned such bans in a few important areas. These include certain forms of obscenity, profanity, libelous speech, and so called fighting words. These forms of free speech and expression are not sanctioned because they are not, according to the Supreme Court, an essential element of any exposition of ideas, and they are of such slight value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. So, the great majority of speech is protected under the First Amendment doctrine of free speech. However, if the language is considered to be obscene, profane, libelous speech, or so called fighting words, then that speech does not have the protection of the Constitution. Okay, so the next slide here is going to be slide 12, and we just touched on this speech that is not protected: obscenity, defamation, libel, fighting words, child pornography, and solicitation to commit crimes. Additionally, true threats, blackmail, perjury, incitement to lawless action. These are also types of speech that will not be protected under the First Amendment of the Constitution. And then next, we're going to go ahead and jump to slide number 17, which talks about double jeopardy. And the Fifth Amendment protection against double jeopardy is designed to ensure that a person who has been convicted or acquitted of a crime is not tried or punished for the same offense twice. Double jeopardy occurs when, for the same offense, a person is one, re-prosecuted after acquittal, re-prosecuted after conviction, or subjected to separate punishments for the same offense. Double jeopardy does not apply, however, to prosecutions brought by separate sovereigns. For example, the federal government, each state government, and each Native American tribe are considered a separate sovereign. So, what that means is that if you were prosecuted for a crime and you were acquitted, found not guilty, the state that prosecuted you cannot re-prosecute you again for the same crime because double jeopardy prohibits that. However, the federal government, which is separate from the state government under which you were tried, can in fact try you for the same crime. If you were prosecuted and then convicted, obviously you cannot be re-prosecuted for the same crime after you've already been convicted. So double jeopardy prevents that kind of re-prosecution from happening. It is important to know that the Blockberger rule applies in double jeopardy cases. Again, double jeopardy prevents a second prosecution for the same offense. A a rather complicated issue in double jeopardy jurisprudence, concerns the definition of what constitutes the same offense. Okay? So the Blockberger rule helps us to understand whether or not something is the same offense, because that's very important in double jeopardy issues, because double jeopardy says you cannot be tried more than once for the same offense. But what is the same offense? So according to the Blockberger rule, an offense is considered the same offense if two separate statutes that define the offense both contain elements A, B, and C. Moreover, if one crime contains elements A, B, and C, and the other has elements A and B, both are considered the same offense because neither statute requires proof of a fact that the other does not. For example, assume that the offense of first-degree murder contains elements A, premeditation, B, deliberation, and C, killing, and that the offense of second-degree murder contains elements B, deliberation, and C, killing. Both offenses are considered the same for double jeopardy purposes because second-degree murder does not require proof of another element that first-degree murder does not. So if a person is convicted of first-degree murder, then according to this example, that person cannot be charged with second-degree murder. Now let's consider separate offenses. Separate offenses can be identified when, for example, one crime contains elements A, B, and C, and the other contains elements A, B, and D. Both crimes require proof of an additional element that the other does not. For example, assume the offense of joyriding contains elements A, unlawful taking, B, of an automobile, and C, with the intent to temporarily deprive the owner of possession. Assume also that the offense of car theft contains elements A, unlawful taking, B, of an automobile, and D, with the intent to permanently deprive the owner of possession. These are considered separate offenses because each offense requires proof of an element that the other does not. One requires you to show that they only intended to temporarily deprive the owner of possession, while the other requires a showing of permanently intending to deprive the owner of possession. Thus, a person who is found guilty of joyriding can also be charged with the crime of car theft. Whereas in our prior example, someone who is charged with first-degree murder cannot be charged with second-degree murder because there is no showing of an additional element in that example. Now, there are some exceptions. I'm not going to go through each one in detail because they are outlined quite nicely in your textbook. But there are some situations where double jeopardy does not apply and the defendant will not have the protection of double jeopardy. Those exceptions are if the conduct is committed after the first prosecution, if the defendant is responsible for the second prosecution, if the court hearing the first offense lacks jurisdiction, and if the defense plea bargains over the prosecution's objection. And that is it for Chapter 2. Now I'm going to move into the final chapter for week 1, which is going to be chapter 3. Chapter 3 deals with the elements of criminal liability, and we are going to begin our discussion with chapter 3 by talking about conduct crimes versus result crimes. Now, conduct crimes are offenses for which engaging in a prohibited act constitutes the full offense. In other words, there's no requirement that any resulting harm occur, only that someone engaged in an action that was prohibited by law. An example is reckless driving. The law generally prohibits reckless driving out of concern that dangerous drivers could cause harm to others, but there's no requirement that harm occur for one to be convicted of reckless driving. A more extreme example is the crime of burglary, which is basically the unlawful entry into a dwelling with intent to commit a felony inside. The crime is complete once the unlawful entry occurs. There is no requirement that the individual actually commit a felony inside of the dwelling. With respect to result crimes, they are offenses that are not complete unless there's an actual harm. And of course, the classic example here is murder. A person cannot be convicted of murder without the killing of another person. A person's death is the actual harm. Another example is arson, which usually entails the intentional destruction of another's property by burning. Without damage by fire, the crime of arson does not occur. Result crimes thus require that elements besides just criminal conduct are in place. And that is known as the resulting harm. Figure 3.1 in your book gave you a diagram of the elements of a crime. There must be actus reus coupled with mens rea, and the actus reus and the mens rea must occur concurrently in order for an individual to be charged with a crime. Now, let's get into the first element, which is actus reus. Actus reus is Latin for an evil act. It is the requirement that a crime contains some criminal act. There cannot be a crime without some action or inaction on the part of the defendant. For example, it is not a crime to fantasize about inflicting harm on someone else. Indeed, it is not even criminal for a person to just intend to inflict harm on another. Intention must be coupled with an action. A simple example of actus reus is the defendant pulling the trigger of a gun and shooting a victim. The pulling of the trigger is a criminal act, or the actus reus. Now, the actus reus must be voluntary, okay? Involuntary acts such as sleepwalking do not satisfy the actus reus requirement, because it is said that anything you do while you're sleepwalking is not voluntary. You're not doing it of your own volition. You're not conscious of what you're doing. And if you're not conscious of what you're doing, then of course the act in and of itself cannot be considered voluntary. The issue of voluntariness is most often raised in the context of criminal defenses. If there is any chance that the action in question is not voluntary, the defense bears the burden of proving that when they committed this act, it was not done voluntarily.